Hello and welcome to Rajya Sabha Television. You're watching The Big Picture with me, Rausan Pereira. Well, amid the ongoing row with Twitter over the delay in the suspension of several accounts, the Union Government on Thursday informed Parliament that it is in the process of amending rules pertaining to the information and technology sector so that social media platforms could be made more responsive and accountable to Indian laws. The government stated that the new rules will also ensure digital media platforms adhere to the Code of Ethics. The announcement came shortly after Union Law and IT Minister Ravi Shankar Prasad told the Rajya Sabha that the government will not shy away from acting against social media platforms if they are misused to spread fake news and incite violence. A spat has been going on between Twitter and the Indian government over a suspension list which contains over 1,000 accounts that need to be suspended or at least blocked in India for spreading fake news and hatred on the ongoing farmers' protest in the country. The social media firm has refused to act against all the accounts mentioned in the list, stating that it will not suspend accounts that belong to the media, journalists and activists to uphold freedom of speech and expression. In this edition of The Big Picture, we will analyze what kind of rules we need to have for social media. Joining me on the program today are Abhishek Singh, CEO, NeGD, Ministry of Electronics and Information Technology, Deepak, Advocate of the Supreme Court, and Rameesh Kailasam, CEO, IndiaTech.org. Thank you to all my guests for joining me on this edition of The Big Picture. All right, Abhishek Singh, let me start the program with you first. Let's try and understand and analyze, what are the kind of rules that the government is working on as far as the social media is concerned, and what are the kind of rules that we need to have?
See, as of now, and especially in the context of the present controversy, the rules under the IT Act, especially the 69A provision of the IT Act, are very clear and very cogent. They have gone through the test of the Supreme Court also, wherein it was examined and it was mentioned that since there is a recourse available for anyone who is aggrieved by any order in 69A to represent themselves, it's a fair law. So having said that, the orders which were passed by Ministry of Electronics and IT under 69A for violating the norms which have been specified, the reasons for passing an order in 69A are very clearly defined in 69A. These orders were passed, and the normal recourse available for any entity against whom an order is passed is that first it has to comply with the order, and then when it's given an opportunity to put up its own version before the competent authority, then that competent authority takes into account of what the party is saying, and then passes a reasonable order explaining the whole thing. It's a very fair, just law which has stood the test of the time. Last year also, when certain apps were blocked for violating data privacy and for violating the security of the state, these orders will pass on the same provisions. This year also, we had a very unfortunate incident on the Republic Day in which lives were lost, and immediately after that, a hashtag was used which could have led to provoking more people, and the word that was used was something which is not acceptable in civil society, and that could have led to violent incidents, loss of life and property, loss of lives. So government was in its fair wisdom examined the matter that was brought on record, identified the handles that were propagating that hashtag, and directed the defaulter platform, in this case Twitter, to block these accounts. They dilly-dallied, they took some time, but after that, when government was firm that if you don't take it, then the consequences of violation of 69A, which means arrest and which means penal provisions, they will also come in force, and they acted together and they violated most of the accounts. There are a few for which also probably I hope that better sense prevails and they will act in that, and then take recourse to the legal remedy which is available under the Act only. And then if a competent court or if a competent authority passes an order, that will be fair for everyone.
Right.
The other pertinent issue in this regard is with regard to regulation of social media platforms, because very often most of these social media platforms always claim that they belong to what they call platforms and they are not publishers. They are not subject to the same level of scrutiny and same level of due diligence that is required for any publishers. For example, a TV channel or a newspaper have to conform to those provisions of the law, but platforms say that here, since most of the content is user generated and they are just the platform which are providing that, they are not liable as for the responsibility that would accrue as a publisher. But very often in cases that we have seen, all these social media platforms do exercise editing, do exercise selective blocking, do exercise selective positioning of content. So for all practical purposes, they are also in the category of publishers and not platforms. And once you are in the category of publishers, then all the rules and norms which apply to a publisher will apply to them also. So this is the debate that is there. And of course, the rules, intermediary rules are to be notified. And once that is done, then they will be better. It will be easier to ensure proper order is maintained and one uses social media in the proper civil sense in ensuring that we ensure freedom of speech of not only the person who is making it, but everyone else who is subject to the same freedom of speech is able to carry out their normal lives as per the norms. This is what the whole issue is about.
Absolutely. All right. And thank you for putting it into perspective for us and explaining the issue so beautifully as to where it stands, what is being done, and how things are at the moment. Desai, Deepak, let me bring you in now. I'll have you also weigh in on this particular discussion and these 2 points that were raised, of course. So from a legal perspective, how would you look at this?
So I think there are 2 situations that perhaps we must consider, and I would perhaps look at them as 2 different baskets, or time baskets, so to speak. One is the position as it existed at the time of the pronouncement of the Shreya Singhal judgment, which Mr. Abhishek Singh was just mentioning, and the kind of circumstances and exigencies that have unfolded post that particular judgment. So until that particular judgment, I think most of us were perhaps on the same page that social media platforms, especially like Twitter and Facebook, perhaps are entitled to treatment as intermediaries. And as someone who participated in the matter, I'm certainly aware of what happened in that particular matter. Therefore, as Mr. Abhishek Singh rightly points out, Section 69A was also under challenge, but the Supreme Court ultimately upheld the vires of the particular challenge, or rather upheld the vires of the particular provision, despite having struck down Section 66A and the corresponding provision of the Kerala State Police Act. So that was the understanding until the Shreya Singhal judgment. But post the Shreya Singhal judgment, what has certainly happened is that a number of instances have raised certain red flags with respect to the consistency and let's say the manner in which social media platforms pixelate certain views, push certain views, or let's say block certain views, so to speak, effectively speaking. And that inconsistency at least has seen a spike in the last 4 to 5 years significantly. And usually the concept of editorial control is seen as that control which is exercised prior to the transmission or the publication of the content. However, when it comes to social media platforms, the fact of the matter is they are in a position to exercise ex post facto editorial control, which is to say, post the publication of the content, they still have certain rights and powers to remove certain content or block certain content under the terms of use as well as the privacy policy, as well as under the guidelines of, let's say, the intermediary rules which they're supposed to have mandatorily speaking. So there is a certain degree of editorial control that even these platforms exercise. Whether it is pre or post does not make a difference as long as you're in a position to interfere with the content, whether before or after publication. Therefore, I think it is time that we revisited their claim of being intermediaries, coupled with the fact that, be it the CA riots or even the Republic Day riots, so to speak, there appears to be significant questions having been raised with respect to their conduct, the manner in which certain hashtags were pushed, and the kind of hyperbole that was indulged in, which could have endangered life, limb, and certainly the dignity of the country on the international stage, which I think certainly matters. Considering that, I think the government is well within its right to, let's say, take stock of the situation and ask itself whether these entities are truly merely intermediaries and can they be treated as publishers who have a certain degree of obligation with respect to the content that is disseminated on them. That I think the government is fairly within its right to do. Any questions of constitutionality, I think, would be premature at this particular point of time unless until we take a look at the details of the rules. But in principle, the government certainly has the power to regulate this particular medium. No medium is an exception to the government's power to regulate under Article 19.2.
All right. So the government is in all its right, really, as far as ensuring that rules come in this particular vertical or sector too, is what the legal expert is suggesting and saying right now. So let's see what happens there. All right. Rameesh Kailasam, let me bring you in now. You've heard the other two panelists. So let's also talk about what is fundamentally wrong with digital platforms as a whole and what kind of rules do they need? How do we proceed?
Well, I think adding on to what Mr. Abhishek and Mr. Deepak said, I mean, if you look at the whole gamut of digital media, and there are multiple forms of it, There are some which have now gone into the bucket of the Ministry of Information Broadcasting and its jurisdiction and the likes. But if you look at social media per se, what is happening is that these social media platforms, I mean, there are of two types. I represent the startup sector, so obviously you have the Indian version of social media, which is there from Indian startups, and you have the overseas players who permeate seamlessly across boundaries and operate. And in the process, what happens is that the world is actually divided into boundaries. The digital medium, the beauty of it is it transcends boundaries, but the bane of it is when it transcends boundaries, it may cross certain jurisdictions, which it should ideally be compliant with and not necessarily trample upon them. We are a democracy, so obviously freedom of speech and freedom of expression and all of that do come into play. And when we look at the laws of the land, but at the same time, I think what is important is upkeep of law and order, and also the fact that if there are offensive content which is there, the platform has to take the onus to decide on the takedown. To be ensuring that the geography that you are operating with, you don't end up messing up with the normal life of the geography. Dissent is a part of democracy, but then to what extent do you stretch it? Now, if you look at the regulation per se, I think a couple of years back, I remember MeitY, the Ministry of Electronics and IT, had come with this intermediary guidelines, which was in a draft form. It did speak of certain important aspects, which I thought I will bring it to the fore, where it actually said that if there is any offensive content, if there is any content that will be damaging, the intermediary shall be bound to inform its user that it's going to take it down, and it had the right to take it down. Apart from that, there were even timelines prescribed on what should be the takedown and all that based on the Supreme Court judgment and so on. But one fundamental thing that was missing was, and this is something we had also reiterated, because we do that in the startup frame of things for both taxation as well as law enforcement as well as takedown regulations, is that most of the overseas players technically do not exist in India. And the concept of permanent establishment, which we have been trying to push for in taxation and as well as law enforcement is concerned, because the entities that operate in India are largely either the back office or the development center or the marketing office or the liaison office. And the true owner of that platform, which is giving the service, is sitting somewhere overseas, which is why we have always had problem when law enforcement was seeking out for investigation of a particular case. Even, in fact, startups have raised this issue where we had asked basically data of people who were actually conning people through these platforms. And you take down some today, they morph into another form and come back tomorrow. We had given that list, but we did not move further on any of these because both the law enforcement and all of us hit up when it came that you have to go through the MBLAT process sometimes to seek data. So obviously, yes, this is a challenge. And the cover that is often taken by overseas players was that, we have Section 230 in US, which gives us that ample kind of insurance coverage, due to which, you're not able to transcend and make headway on genuine issues even.
Right. All right. So let's take the discussion forward now. Abhishek Singh, several media houses have reported that the government is leaning towards the direction of a mechanism where we see self-regulation as far as this particular sector is concerned. Do you believe that that is the best way to address some of the issues that have now come up?
See, digital media regulation is something where normally self-regulation is prescribed because the amount of content and the volume of content is so much that if the government would have set up something equivalent of what was done for, say, films and all, a censor board, it would be virtually impossible to screen every content before it goes online or something. So the only effective way could be to lay down the broad guidelines, to lay down what is permissible, what is not permissible, and then expect self-regulation to carry on. And that has worked well for in various sectors, and it can work well for social media also. But having said that, if by self-regulation, if any entity indulges in violation of any law of the land or any provisions of the constitution or the legal or the statute books, then that entity will be taking that as a risk, and that would entail whatever consequences come in. So while self-regulation is there, but 69A is also there, 19(2) is also there. So one will have to be conscious of the responsibility that one has, and especially in the kind of the number of volumes, the number of people who use these platforms. If a fake news is floated, or if some anti propaganda is put in there, which can inflame religious or other emotions, then it can lead to violence. It can lead to loss of life. So government cannot sit as spectators of such kind of thing. So there has to be effective measures. There has to be examples wherein any major violation is dealt with sternly. The law stands clear, because if tomorrow you don't do, then there will be precedents. You didn't do, then why are you doing this now? So it has to be enforced in the letter and the spirit. And one would expect that any social media platform or any tech company who is launching its product in India, they would be conscious of the sensibilities of the nation, of the people, of the law of the nation, and they would be as law abiding as they are in their own countries. Like none of these platforms could think of violating these laws in the US. Or there, in fact, when there were certain violations made, they would immediately flag those tweets and post as something which is not true or which has been found to be wrong. And they even ended up blocking the elected president of the United States from their platform for violation. So when you are so aware of the provisions of the law in the country where you have been incorporated, if you are operating in any other country, you have to abide by the similar standards. This double-edged hypocrisy will not work. So government has to be firm of what government has to do to safeguard its own interests, and any tech platform which is operating in India has to abide by the law of the land.
Absolutely. All right. So, Jesai, Deepak, let me bring you in now and take forward with you two particular aspects. One, of course, about how there are doubts about social media giants and their commitment to transparency, and that is something that has been an issue of late, we've noticed. Secondly, when this issue between Twitter and the government of India came up, Twitter immediately said that we are not doing anything that is against the Constitution of India. They said that they are only safeguarding freedom of speech and freedom of expression. And what happens to creative ideas then?
So I certainly believe that it's possible for everyone to say that all of us stand for free speech and expression. I don't think that's in question at all. The simple question is, when a government issues a directive, what is your response to it legally? It can't be your argument that I have the right to free speech and expression. I'm sure that entities such as Twitter and Facebook are aware of the limitations on the free speech and expression also, notwithstanding the fact that they believe that they may be in the business of disseminating free speech and expression. Therefore, unless and until they're in a position to challenge the directive issued by the government in a court of law, explaining what is it that the government has done which is unreasonable, I don't think they have the luxury of pontificating from their own handles about their respective positions. Let me be blunt here. I don't hold brief for the government. I'm not someone who wants to be a mouthpiece of the government on this particular issue. But in the facts of this case, I certainly believe that a hashtag such as farmers genocide was crossing the line significantly and overshooting it beyond acceptable limits. And when you know for a fact that there is a certain conflagration that's going on, or there is a certain disturbance that's going on in the national capital territory, I would have expected this particular entity to behave with a certain degree of responsibility, or any entity for that matter. So in the facts of this particular situation, and going by what is the directive issued in the context of, I am unable to convince myself that the government was in the wrong or unreasonable in its actions. And free speech and expression is not supposed to be used as, let's say, a much abused shield, or let's say some kind of a wall to hide behind. When your actions as an entity, as a responsible entity, are under scrutiny, you might as well explain what your position is. I don't think free speech and expression translates to a free license to anyone to willy-nilly turn a blind eye to the law, particularly when the situation is sensitive. And you have contributed significantly to that particular situation as a consequence of promoting certain hashtags. The government has the right to pierce the veil to understand who are these entities and who are these individuals who are operating those handles. And if a private entity believes that it can call the shots without necessarily doing what the government expects it to reasonably and legitimately, I have to certainly ask myself this question. As someone said, is this Twitter East India company? Because this is not the response that this particular entity would have given to any other body had they been called for a Senate committee hearing meeting in the US or anybody else or anywhere else. They would have gone before such a committee with their tail tucked between their legs and submitted to the jurisdiction of the particular body. Here, if Twitter operates under the belief, or Facebook operates on the belief that they are not answerable to anyone, I think then the government must stand up, because it's not a question of the government, it's a question of the Indian state, and I strike a conscious distinction between the government and the state. Therefore, this is not a challenge to the government, so to speak, or individual egos, so to speak. This is a challenge to the might of the Indian state. And I think the Indian state must respond in kind within the means of the constitution, staying within the bounds of the constitution.
All right. Rameesh Kailasam, let me go back to a point that Abhishek Singh was making about the volumes and how the volumes are extremely high as far as digital content and digital platforms are concerned. So are rules and laws enough to put an end to, hate, to put an end to fake news, to put an end to bots? How do we do that? How do we put an end to it? Don't we need technology as well?
So this is an issue that was squarely dealt with in the Shreya Singhal judgment, where the quantum and the volumes that we are looking at in terms of user-generated content was certainly considered by the Supreme Court. Now, here's the interesting question that I have to ask myself. If it is the claim of these entities that the volumes are such that they are not in a position to pre-screen anything, they, I think, are shifting the goalpost, because it's not a question of pre-filtration, it is a question of post-filtration as to the conduct and consistency. Okay. The argument that was made before the Supreme Court continues to be valid, according to me, to a significant extent, to say we may not be in a position to regulate all content at the outset before it reaches the public eye. But what do you do after it hits the public eye, and after a certain red flag has been raised either by the community, either by the users, or your own people watch and realize that there is something terrible that's going on, or the government or a security agency or an enforcement agency has issued a notice? So I think it makes very little sense for them to try and shift the goalpost by saying, how can we police the content at the outset? One, there are technologies which they may want to discuss in public, and perhaps this is a question that needs to be revisited. In terms of pre-filtration technology, perhaps we should have an open discussion as opposed to proceeding on the basis that there is no possibility of pre-filtration.
Right.
I'm sure entities like Twitter and Facebook have a solution to everything. Nevertheless, as far as ex post facto filtration or ex post facto censorship is concerned, I don't see how the quantum of the, let's say, content that is generated comes to their aid in that particular regard, because that's precisely why they have community support mechanisms. That's precisely why they have a certain officer who's supposed to respond to notices from the government. To say that I can't take responsibility for the content before and after is to say that there must be absolutely no regulation at all whatsoever as far as this particular medium or the platform is concerned. That I don't think is an argument that will hold water or cut ice anywhere in any jurisdiction, certainly not in India.
Rameesh Kailasam, since we are here, let's also talk about another aspect. Building on what Sai Deepak has just said, most digital platforms are open, free for all platforms. So will too many rules go against the tenets of these platforms?
Well, I think the fundamental part is that you do need freedom to operate, and over-regulation is anyway something which is not something anybody is supportive of. But at the same time, I think the borders should be drawn. There should be more clarity in regulation, and there should be more communication of clarity of regulation, which I think is necessary in the current context, because if you look at it, there are perceptions based on which certain things have been assumed. There are perceptions based on which certain laws have been assumed and the meanings have been interpreted. And therefore, it is all the more necessary for the government to come out and clarify on some of these, possibly in a more concrete way, specific to the new emerging line of businesses, because, as I said, these things existed, but the newer forms of business have assumed certain rules and regulations, which may not be in line with what the actual thinking should have been, based on the context that we saw got played out in the open. And therefore, it is, as I said, not over-regulation, but at least clarity of regulation is important to be communicated now, and I think it's time for it.
Okay, time to get closing comments now from all my panelists with the best way forward. Starting first with you, Abhishek Singh.
Yeah, but I would just conclude by saying that India has been welcome to all tech companies, global players. We are not like some other neighboring countries wherein major IT companies are not allowed also to operate. So we have been welcoming. But then when we do so, we do this with the expectation that they will abide by Indian law, they will abide by Indian rules and constitutional provisions, and we'll expect them to do that. So once that is done, I think this issue will be resolved, and we expect all of them to grow, prosper, make money, but at the same time respect Indian laws. That's what I would like to say.
All right, Sai Deepak.
I do believe that entities which enjoy a large following certainly are in a position of responsibility, and they must understand that the manner in which they choose to abide by the law and conduct themselves effectively sets an example for every other entity in that particular space, especially the startups. Therefore, it would help if these entities operate within the four corners of the constitution. Nobody expects them to be subservient to the Indian government in terms of saying lie supine and give up all your rights or concede your space. However, what is legitimately expected in an extraordinary situation must be complied with. And if they could get their act in order, I think it would help all of us, because I think at the end of the day, these platforms, to give credit to them, have certainly democratized the dissemination of public opinion. Therefore, it would help if they conduct themselves in a manner that encourages or gives more confidence to everybody that they are part of a certain platform that understands the line that has been drawn in the sand between what is right and what is wrong, what is legal and what is illegal. If they can do that, I think it is in the best interest of free speech and expression, which they claim to profess, practice and preach.
All right, and Rameesh Kailasam, close the show for us with your concluding remarks.
I guess social media has contributed in a big way and democratized the whole process of information dissemination. And more importantly, today you see government as one of the most active participants in the social media. In fact, every announcement, if you look at whether it was lockdown or whether it was in terms of the whole pandemic, the communication was coming through these social media platforms and the government was leveraging it. What is more important, therefore, is that this self-governance or self-regulation which is being practiced should be practiced in its true sense, and any breach of that actually puts at risk the potential of freedom that not only the current social media platforms enjoy, but even the future ones that may emanate.
All right. On that note, then, I'll call it a wrap on this edition of The Big Picture. Thank you to all my guests for joining me on the program and putting things into perspective for us. What's coming out of this discussion is that for far too long, digital platforms have been hiding behind the wall that they are not publishers, and the content that we see on these digital platforms is mostly user-generated, so they should not be held responsible. We need to revisit this particular claim that these digital platforms or social media platforms are just intermediaries, and because they have the capacity to pre and post edit content, so they should be held liable as far as the content that goes on these platforms is concerned. The government has the right to regulate, and no sector can be outside the purview of government intervention. And let the social media giants not mess with local geography and abide by the rules of the land. With that, it's a wrap. See you again next time.